So I want to thank everyone for joining us today. My name is Kelsey Funes, and I'm the chair of Division One of the forum. And we are so excited to welcome Cliff Shapiro, who's going to talk with us today about guided choice mediation. Before I introduce Cliff, I just want to remind folks about the Pittsburgh meeting happening. I think I should have checked the date. I think it's October 24th through 26th. We are, Division One is also having our planning retreat. And so that will be, no, I'm sorry, it's October 25th through 27th. So our planning retreat is on the morning of October 25th from 10 to 12. So if you're going to the Pittsburgh meeting, and I hope you are, I hope you'll join us. But now let me introduce our speaker. Cliff Shapiro of Shapiro Dispute Resolution in Chicago is a national arbitrator and mediator with more than 37 years of experience resolving construction disputes and insurance claims, including 23 years as the leader of construction law practice groups at nationally prominent law firms. He's handled and resolved virtually every kind of claim or dispute that can arise out of a construction project, and has in-depth knowledge of insurance coverage issues, which often enable him to help parties resolve disputes. He's on the American Arbitration Association's national roster of neutrals for large, complex cases, including in particular disputes involving construction, insurance, and commercial matters. He provides self-administered mediation services as well. He regularly provides mediation and arbitration services throughout the United States and has provided ADR services virtually via Zoom and other remote meeting platforms. And you can find more about him on his website, shapiroar.com. And I guess before I hand it over to Cliff, I will say that a couple of years ago, Cliff, well, more than that, maybe 5 or 6 years ago, Cliff and I were co-counsel in a case, which is how I met Cliff. But he was a mediator for me in one of my cases, and he used his voodoo guided choice skills, and it really impressed me and intrigued me as an advocate and as a mediator myself. And I'm really excited for folks to learn more about this process and how it works and the benefits of it. And so I'm going to hand it over now to Cliff to tell us about guided choice mediation. Anybody, if you have questions or want to discuss anything as he's moving through, you can raise your hand. I'll try to keep an eye on that, but put comments in the chat.
All right. Well, thank you. It's great to be here, and I'm excited to talk about this because, you know, I actually have been thinking about this quite a bit, and I've tried to distill this thinking into what hopefully will be about a 30-minute discussion. And so, you know, look, what we're going to talk about is what is guided choice mediation and what's a guided choice mediator. But before I go into it, I have some major disclaimers or caveats, and that is that what I'm going to do today is really the Cliff Shapiro view of mediation. Okay, and I think it is true that through the years I have incorporated and adopted many of the guided choice mediation principles in the way that I approach mediation. And I know there are a lot of other mediators these days who are doing the same thing. But the term guided choice mediation, I believe, started with Paul Lurie out of Chicago. I think he's the one who coined that phrase. And guided choice mediation is a principled thought process around mediation that does exist as a guided choice mediation set of principles. And so I'm not sure I'm going to be talking exactly about that, okay? And I would encourage you to go see Paul's website. Just Google guided choice mediation, you will find it. And there are other practitioners who are very enamored with and advocate for guided choice mediation, including Jeremy Baker out of Chicago, who has a series of videos on his website about this. Dean Thompson and Mark Becker out of Minneapolis also are major proponents of this. But in my view, you know, the distillation that I want to talk with you about today, I think is guided choice. And it certainly adopts a lot of the guided choice principles, but I just want to be a little careful that it may not mirror exactly what the advocates of pure guided choice say. All right, so with that caveat, let me go forward. So what is guided choice? Well, it is not what we might have seen in years past, okay? I mean, I think we all had experience and maybe still have experience sometimes with what I would call the standard or historical approach. And you know how that goes, you know, the parties or a dispute resolution service, they pick a mediator. The mediation is scheduled, often based on a scheduling order. The scheduling order says, well, you got to go mediate. And so by a certain date, they set a date for the mediation. And about a week before the mediation, something is given to the mediator. The parties might or might not share those. There are certain parts of the country I've run into where the normal practice is not to share your mediation submissions to the mediator. And then everybody shows up and they hope for the best. All right. And a lot of times those kinds of mediations, I think, are often what we would used to call facilitative. The mediator would go back and forth between the rooms pretty much just with numbers and without a lot of other discussion about the merits. So that is not what guided choice mediation is. And I guess when I was thinking about this, where I got to was let's step back. What is the fundamental question that we're trying to answer? And I think the fundamental question that we're trying to answer about mediation is how do we ensure that the parties are at the mediation with reasonable expectations and appropriate settlement authority? And I think that is what we're really talking about. We're trying to find a process that allows us to get there. And so guided choice mediation, or in my view, good mediators answer that question by saying, okay, what we have to do to get there is we have to create a mediation process for this particular dispute that allows the parties and the mediator and related insurance companies to engage in a critical risk analysis before and at the mediation. And in my mind, that risk analysis is really important because that is the core of getting to a reasoned approach and reasonable settlement authority. All right, we're going to talk a little bit more about that. So guided mediation, in my view, to get to that goal, incorporates these key elements. Early engagement is a big tenet of guided choice mediation. And Paul Lurie really emphasizes that what you have to do is engage the mediator very early on. And so that is often a good thing to do because you can use your mediator to facilitate this whole process for dispute resolution in ways that a lot of times people don't do. What I find is that there is still resistance to that. There are mediators and advocates around the country who are beginning, and this number is growing, and people are beginning to understand, yes, let's get the mediator involved early so that we can facilitate an exchange of information and do this early and not necessarily with the cumbersome process of the court. But I find in my practice, it is still fairly common that people are coming to me after they've been litigating a while and they already have some information. But I do have a lot of matters where people are coming to me pre-litigation or right when litigation is filed. So, but early engagement is an important piece of this because you can use your mediator in really better ways if you do this. But another key thing about guided mediation is a customized plan for this dispute. And that ties to things like the next item here. The mediator has to help you facilitate the information exchange. So the first thing that the mediator should be asking you is what information do the parties have and what information do we need so that when we get to the mediation, everybody will have had enough information so that they can analyze the risk of these claims sufficiently to be able to mediate, to negotiate. And that's critical. And it's not easy, okay? I mean, particularly where you don't have full-blown discovery, there's a real art form here to getting enough information or the right kind of information without going through the full expense of full-blown litigation. And that's one of the big benefits of mediation is figuring out what do we really need and getting there through the mediation process. Another key element is mediator involvement with the insurance issues. There are way too many times where people show up at a mediation, they have carriers there, and the carriers don't even have settlement authority because they got something 2 weeks before. Maybe they even got it 6 weeks before, but that's not enough time for an insurance company to do an analysis on a big claim. There are layers and layers of bureaucracy that they have to go through to get a settlement authority. And so mediator involvement to making sure that when you get to the mediation, you're actually ready to settle involves involvement with insurance issues. And it also involves being able to deal with the complex coverage issues that can arise in the construction context. Another key element of guided choice mediation, in my view, is the use of pre-mediation ex parte meetings. We didn't used to do this. And frankly, it was COVID that taught me how to do it. You know, we all have the crash course on how to use Zoom. And now that we know this technology works, it is really becoming pretty common for mediators that are using this kind of approach to get together separately with each party before the mediation. Usually this will happen after enough information has been exchanged so that the mediator can start the process of helping the parties look at the risk profile for the claims. But also there's something about these meetings that I find just fascinating, how helpful they are. There's something about meeting beforehand, and this isn't just the lawyers. You have to include the key decision makers who are going to be at the mediation so that you're beginning to get to know them, they get to know you. And there's something about having already met before the mediation that seems to really help at the mediation because you have started the process of building trust and both ways. And I find that to be really helpful to resolution. So that is a key part of, in my view, guided choice mediation is being able to effectively use those kinds of meetings and include them in the process. And the other key thing in my mind is this mediator participation in the risk analysis. So let's talk a little bit more about that. So I think this is critical. And we used to differentiate, is the mediator facilitative or is the mediator evaluative? I guess this would fall on the side of being evaluative. And when we talk about risk analysis, what we're talking about is simply that you can say it simply, it isn't simple, but what we're talking about is the risk of winning or losing at trial. All right, that's what we're really talking about. What is the probability that the claimant is going to prevail at trial? And what is the probability they're going to lose? And the same thing with the respondent, okay? And if you have multiple parties with multiple tiers of subcontractors, you need to be doing this risk analysis at every layer with every party. What is their ultimate exposure and what is the probability that they're going to be winning or losing and how much? Because if we can get there, if we can get real thinking about that going, then we can monetize that risk and then we can negotiate. So I think this is critical. And I think it's the foundation of which a negotiated settlement should be based on, okay? And so this needs to start before the mediation, okay? And then at the mediation, it needs to continue. But it really is very important that enough information be exchanged, including expert reports, draft expert reports. I mean, the beauty of mediation is you can agree on the process as well. Are we gonna put together some draft expert reports that will stay covered under the mediator privilege for purposes of this mediation? Or are we going to do full-blown expert reports? So we've done that in case we don't settle. All of that can be talked about and planned as part of the master plan, the custom plan for this mediation. But I think this is a critical piece. And so, in my view, guided choice mediation has a mediator who's prepared for the risk analysis. Now, that means the mediator has a lot of work to do, okay? In these kinds of cases, the mediator really has to, not just the parties, but the mediator has to get the information. The parties need to share the information, okay? I mean, I think that's critical too. There are parts of the country where they don't do that as a matter of course. I don't understand that. How can you do the risk analysis if you don't exchange the information? Now, sometimes there are private or confidential things or just something you don't want the other side to know, but that's fine. Send that to your mediator in a separate confidential submission just for the mediator's eyes. I should know about it. Even if I can't tell the other side, I should know about it so that I can help and really do a full-blown risk analysis with you. And so in my view, the guided choice mediator is not just evaluative, they are a risk analysis facilitator. It's not like the mediator, I don't, look, I'm the new guy on any case. Everybody knows the case better than me. I'm drinking out of a fire hose. And so I'm not suggesting that the mediator should come into the room of a party and immediately tell them how it is and what the risk analysis is. I think the mediator should be much more subtle and use a be a facilitator of the risk analysis. And most mediators know how to do this. You ask a lot of questions, and the way you ask your questions oftentimes shows the parties what you're thinking. But also, in my view, a mediator usually starts off, the best practice is to start off asking a lot of questions, really understanding the claim, so that later in the day, when you've gained the trust of the parties, hopefully, and they have a feeling that actually you do understand their claims because you're prepared to talk about them, then later in the day, as you're looking at nuance and trying to figure out where you're actually going to go with dollars, there can be perhaps a more expressed view if asked. I usually wait until I'm asked, but if I'm asked, you can usually then be more truly evaluative. This is how I think this would go. And by that time, hopefully the parties are trusting you enough that it's meaningful. Okay, so I think that's critical. Now, that's not to say that you're not also a facilitator. A good guided choice mediator also needs to have the ability and be facilitative, because you have to facilitate the negotiation process. And so you need a mediator who understands what it means to make a certain kind of offer. And we all know that numbers speak. And so the mediator needs to be able to understand and appreciate what it means when you send a certain number into the other room. Okay, is that number a number that is basically a number saying go screw yourself? Or is it a number that is truly inviting a counteroffer? Okay, and there are various points along the process where sometimes you really want to be showing flexibility, but there are some times where you don't want to show flexibility. And this is largely the party's discretion, but the mediator needs to be there to help the parties figure out how they would like to go forward, and in that way facilitate the negotiation. Also, the mediator, look, in facilitating negotiations, you have to anticipate and try to overcome impasse. So we used to, and maybe people still do, talk a lot about facilitative and evaluative. In my view, a guided choice mediator is both, as appropriate at a particular time in the process. So look, this key attribute really is a customized process. I think everybody who talks about guided choice, that is a key attribute. You up front, the mediator, the first thing that happens is the mediator gets together on Zoom with all the lawyers, and you talk about the process, and you talk about what kind of information needs to be exchanged and how we're going to do that, the timing on that. And then you can talk about also the structure for the mediation itself. There's a big question out there about whether you do any sort of opening statements. The general feeling these days is pretty negative on that, but there's exceptions. There are times where it actually helps to make presentations still today. There's some disagreement about that out there in the mediation world, but I think there are times where it can be appropriate. But that's something that you need to talk about, how you're going to handle that. So this customized process is critical to the idea of guided choice mediation. There's also, a focus on efficiency. Good guided choice mediators really try to find a way to do enough, but not too much, so that you can, use this process to ideally early in your dispute, or earlier certainly than you would get to in litigation, get to resolution and do it in a cost-effective way. And so I think that is also an emphasis, and that's part of this whole customized plan. Now, look, I also think that parties sometimes don't understand. The lawyers usually understand, but parties don't sometimes understand that even a failed mediation is almost always not a failure for the case. The mediations that go through this kind of process really advance the ball in the knowledge that the parties and their lawyers have about the claims. And so if you go through this process and you're not able to resolve, usually you have materially advanced the ball on how the claims will be arbitrated or litigated. And that can actually help save costs too, because it can really highlight what's really important and allow the lawyers and the parties to go pursue what's really important in a way that might be more efficient than if they hadn't had the mediation to flesh that out. So what are the key attributes of a guided choice mediator? Well, it's a mediator who is ready and willing to collaborate with the counsel. I think this is a collaborative process up front, and create that custom mediation plan. Sometimes that's a bit of a mediation, negotiating between the parties on how are we going to do this. So mediating the creation of the mediation plan is, I think, a key part of being a good guided choice mediator. Helping the parties with that information exchange and facilitating that. Sometimes the parties need you to prod the other side, or they don't get something that they think that they need. And so in that way, you're not an arbitrator, but as a mediator, you can help facilitate that information exchange. And that can really, be very helpful, particularly where the parties need a little help that way. The mediator needs to and should, in my view, facilitate the insurance involvement. And oftentimes it's just asking the parties the questions they might not have thought of. Who are the carriers? Please send me an insurance schedule showing all the involved or potentially involved insurance companies. And are all these parties on notice? Are all these carriers on notice? Are they going to be at the mediation? Do we need to reach out to them and find out if they're coming to the mediation? How much time do the carriers need in advance of the mediation to be able to become prepared with settlement authority? And then what we often run into in the construction world is, do we have coverage disputes? I mean, are we going to have a mediation within the mediation to deal with, is defective work covered by the policy? All of that needs to be anticipated up front so that we can have a mediation plan that anticipates that and is prepared to deal with it. So when we get to the mediation, we're actually ready to resolve the dispute. And also, a key attribute is this mediator needs to be able to participate in the pre-mediation meetings in a way that is helpful. And again, probably not coming out of the box and telling the parties all about their claims, but listening at first and helping develop some rapport and trust between the mediator and the counsel and the parties. As we've talked about, a good guided choice mediator needs to engage in appropriate risk analysis discussions before and at the mediation, and be able to facilitate the settlement negotiations, watching out for potential impasse that might be coming. And when you hit an impasse, helping the parties find a way through it. And another key thing is, I'm frankly a little surprised at how often, when we don't resolve at the first day of mediation or the first mediation, staying involved and being willing to stay involved results ultimately in a resolution. Sometimes what you learn at the first mediation is that there's some key issue or issues where you need more information. Maybe a motion needs to be made before the court. But staying involved and with the parties through that and helping them facilitate that process to get to the next mediation is sometimes critical to getting the dispute resolved efficiently and timely. So, question, is it the Holy Grail? Okay, is mediation the Holy Grail? If the ultimate goal is to have a mediation process that facilitates a rational, well-informed settlement as early as possible, yeah, I mean, it's not the Holy Grail, but it sure seems a lot better than what used to be done or what maybe is still done sometimes. It can provide a mediation process that's flexible and customizable, tailored to the unique needs of this dispute, and designed to put the parties and the mediator in the best possible position to resolve the dispute at the mediation on a reasonable and rational basis. There are some limitations. There are times where this approach maybe is not the best approach to use. First of all, the parties have to be willing to participate. I mean, this is a completely voluntary process. The mediator has no real authority, so everybody has to buy in to this process, and not everybody is ready to do that. And they're certainly not always ready to do that early. Okay, there's still, I see out there, a fair amount of resistance to that. I think it's worth trying to convince people that they should come in earlier, but I still find as a practical matter that sometimes is difficult. The cost. to have a mediator who is truly prepared and to go through this process of making sure that the information is exchanged the way we've been talking about can increase cost. It can take longer. Your mediator may be spending more hours working on your matter. Some mediators, what I finally got to, for the first couple of years I was mediating, I didn't do this. And then finally, I just got to the place where I created a flat per party rate for the mediation. So if there's 1 day of mediation, there's a flat rate. It includes all the pre-mediation work. And I'm finding that is really helpful. The parties, and particularly insurance carriers, they know what the cost is. They trust me to do what I need to do to be prepared to be at the mediation with them. And on some matters, I do better. If you were to look at the number of hours, on some matters, I do a little better. On some, I do a little worse. It all works out. And so that's something to think about too. But the cost can be higher than the other kind of mediation. And so it needs to be something that, the parties are ready to do. And, I was thinking about this, it isn't suitable for all disputes. This approach, it does require counsel and parties who want to resolve their dispute, and they're ready to cooperate, and they're ready to be reasonable, and they're ready to do a risk analysis that is not just emotional, but, really is based on the facts and the law. And not all cases get there. I mean, in the construction world, we've all seen certain personalities that are just not suitable for this approach, And there are some cases where the parties really should go to trial. They are in a position where they are never going to agree on the risk analysis. They really there's no way to move them off of their risk analysis. They are so convinced that you're not going to get the kind of movement you would need to resolve the dispute. And so, I think a good guided choice mediator tries to flesh that out a little bit in the early stages, because if you see that there's really not a good probability of resolution if we do it right, maybe the money is better spent on litigation or arbitration. And so I think there are some limitations. I think they really have to have a good group of cooperative people who are ready and able and willing to do what needs to be done to go to this kind of mediation.
And Cliff, as we kind of get to the end of our 30 minutes together, I guess I wanted to jump in with one comment and one question. I can tell you that as having been an advocate in one of these mediations put together by Cliff, it did really help to focus us on we didn't settle, but it did really help to streamline the discovery, because it identified, I think, the real areas of dispute and sort of highlighted the things that I thought the arbitrators were going to have questions about. And so I do think it helps streamline for the rest of the case the discovery efforts. But your description, because so many construction contracts have sort of mandatory mediation provisions. So I think in a lot of our cases, it's something that'll be discussed early on in the case. Having done this for a few years now, do you have an observation about sort of when in the process this can be most effective? Given the time that you're talking about, it takes for sort of briefing and meeting with the parties and meeting with adjusters when there's insurance involved. Do you have any sort of rules of thumb that you've kind of come up with from your experience doing this over the last several years?
Well, so it's interesting whether it's before litigation or after litigation has been filed. So if you're before litigation, I think that is and the parties are ready to do what needs to be done to exchange enough information to be able to do the risk analysis. I think that timing can be very flexible, which is great, because you may need a fair amount of time in that circumstance. What I find frustrating is that the standard form construction contracts, with this step process where you have to mediate before you litigate, but it's got short time frames on it. And sometimes parties file the litigation and they put it on hold while they go and try to mediate. I think that it can be counterproductive to this kind of mediation. Because sometimes if you don't have any discovery yet, you don't have enough time to do what you need to do the critical risk analysis that I think is necessary, but in a complex case. And so, the other thing that I ran into a lot was if you're in litigation, which, litigation can actually, I used to always say, litigation can actually be a tool for dispute resolution. Because of the discovery process, it can be very helpful to dispute resolution. But there's risk there because once you're in litigation and you have a scheduling order from the court, that also is a big issue. Now, fortunately, in Cook County, Illinois, the judges, for the most part, were very receptive. If the parties came in and said, "We are trying to mediate, we need a break, we need some time here, judge," the judge would be receptive. But if you went into the federal district court in Chicago and asked for that, the judge would usually not allow that. Once you had a scheduling order in federal court, you were on schedule. And so, and you'd have to fit your mediation into that process, into that timeline.
So, we're at the end of our time together. I want to thank Cliff. This is so informative, and I want to let people know that we will post this on our blog, the Dispute Resolver blog. And the forum will post this on their YouTube channel as well. But if anybody wants to leave us, because we are at the end of our time, I thank you for joining us, and I hope I see you in Pittsburgh. Cliff, do you have a second for any more questions if anybody else has questions?
Oh, sure.
Okay, so yeah, so this is the end of our official call, but if anybody else has more questions, Cliff can stick around. So thanks so much.
I've stunned them into silence.
It was very informative. Nobody has questions. Well, thank you so much, Cliff. This was so great. And I'll circle back with you on the thing that'll the video get posted in your PowerPoint.
Okay. Yeah. And I'll shoot you a PDF of the PowerPoint so you've got that.
Okay, great. All
Okay.
right.
All right. Take care, everybody.
Thanks, Cliff.
All right. Bye-bye.
Thank you.